We have Lori Goldstein with us tonight, and Lori is an employment attorney. She handles cases on both the employee and employer side, which kind of gives her a unique perspective. And Lori's won lots and lots of awards, and she's just an awesome attorney. But honestly, knowing Lori from networking and just getting to know her over the last few years, she's just loves her job and loves what she does. And we thought that she could give us some great insight into new employment rules and regulations. So, Lori, take it away.
Thank you, Lorna. I'm going to share my screen so we're not just looking at me. Oh, slideshow. Okay, you can see that?
Yep.
Oh, great. Thank you again. Thank you to Lorna and Janine and to ANA CPA for the opportunity to talk with all of you. Thank you for being here, especially those of you that are in the heart of tax season. I guess it's a nice break. And this is a great resource for yourselves, for your clients, and others through this Ask an Accountant event. And I like that you pivot and get information from people besides accountants. So this is the Ask an Employment Lawyer version. So whether you're a business owner or an employee, a contractor, or an HR rep, or you represent any of them, the topics we discuss should hopefully be relevant to you. I regularly work with and refer people and businesses to accountants. I know how tight the industry is and how hard it's been, what the shortage is in your industry, and that's challenging. Also, you know, it's hard in several industries, as we know, to find and retain employees. That puts pressure on everybody, that can lead to challenging work environments, tempers, arguments, burnout, excessive work hours. We had the great resignation from the pandemic, people leaving jobs, going into their own business, a lot of entrepreneurs now. We also have a lot of mergers and acquisitions going on, as people like David know, and a lot of PE companies are buying up companies. So there's a lot of sales, and it's important, just as an aside, with M&As to do the due diligence, including making sure as a seller that you're complying with the employment laws and everything is the way it should be. And as a buyer, to make sure that you're not getting into a hornet's nest. These days, a lot of employers, are now, you're seeing a lot of the reductions in force because a lot of companies, especially in the tech industry, hired too many people during the pandemic. So now we're seeing a lot of reductions and severance agreements, and people moving around or trying to, even though they might have non-competes. So today, there's been developments in the law. They change all the time in this arena. But today I'm going to address a few changes under federal law, state and local, meaning Chicago, Cook County, from the past year for 2024, and then a couple of things that are pending. We'll see that some laws apply to companies, whether they have one employee or 1,000. And there are other laws that only apply to certain size employers. Some laws require 15 or more employees. Others, you need 50 or more employees to be covered. And we'll go through the PowerPoint and save time at the end for questions, but it's a small group. So I would love interactive conversation. If you have questions during, just send it to the chat, and Lorna will let me know when there's questions. So first, whether worker classification has continued to be a challenging and expensive issue for employers and for accountants. I'm sure this is one of the things that you encounter a lot. And we know that it's easier and cheaper for a company to have contractors than employees. They don't have to pay benefits. They're not covered by most employment laws. You don't have to pay for their expenses. But they have to be true 1099 contractors in order for the company to be lawfully not paying payroll tax and FICA and unemployment, etc. And misclassification can be expensive. Some of you may have had clients who have gotten in trouble, whether they've had audits or somebody's made a claim or class action. It can be very expensive. And, typically, if you've done it wrong, you can't say, I didn't know what the law was. I mean, you get in trouble, there's penalties and damages and attorney's fees. We know that there have been various tests over the years for what's a proper classification for an independent contractor. And so today we're going to focus on the Federal Department of Labor final rule, which is the test under the Fair Labor Standards Act, which is the statute that governs wages and overtime. So this is the employee perspective from the Department of Labor. And there's a lot of misperceptions about independent contractors and what's okay and what's not okay. We know that just saying that we've decided, the two parties have decided we're going to make this a contractor relationship doesn't fly with the Department of Labor or the IRS. And having a written independent contractor agreement with all the bells and whistles that would be a proper independent contractor agreement doesn't make that person an independent contractor. So you have to, talk the talk and walk the walk. It's considered now an economic reality test. So this is something that really is about the reality of the relationship more than what's written on paper or what they've agreed to. And companies in the last few years, between people going into their own business for the first time, companies that have been growing. I have a lot of mental health practices, and there have been, that industry's booming. Either individuals are trying to open up their own practice, but they have non-competes or non-solicits with their prior company, or they have a few 1099 therapists that work for them, but they want to formalize now and convert them to W-2s. So a lot of times it's dangerous. I mean, it's risky to convert, but you have to bite the bullet. It's riskier not to convert somebody if they should be a W-2. So the Department of Labor had a proposed rule a couple of months ago that had 6 factors to it. And they've came up with a final rule as of March 11th that now has 7 factors. They had received 55,000 comments for the proposed rule from individuals and organizations. And by the way, the next issue of the Illinois CPA Society Insight magazine will have an article that I wrote on 1099 final rule, if you want to learn more about it. So the final rule has the 6 factors. And the key, again, is whether the worker is economically dependent on the company, or are they more on their own, able to earn money without having to be dependent on that company. It's not enough that somebody's working from home. It doesn't matter if somebody's working 3 hours a week. That doesn't make them a contractor. That makes them a part-time employee. It doesn't matter if you hire somebody just for a project, then they're a temporary employee. So they have to fit the test in order to be a contractor. And so control used to be the be all and end all for what meant contractor. If the employer had control over what the worker was doing and told them where they had to be and when they had to be there, and evaluates them and decides on everything that relates to their performing the work, that's really a W-2 employee. That's not an independent contractor because they don't have control. If a worker has opportunity to profit and loss based on their own initiative, so if they have their own business and they're doing accounting work or tax returns for a number of different clients, depending on how much business they get, they have the opportunity for profit or loss. They're investing in their own business. Similarly, if a worker invests in their own equipment, that tends to suggest a contractor. However, just because a company tells you we're not going to pay for your equipment or we're not going to reimburse your expenses doesn't mean you're a contractor. It might mean that the company's violating the law because you're an employee and they should be paying for this. How much skill is required? So the more skill that's required, the more it would tend to be a contractor. Usually, in positions like accountants, attorneys, people doing bookkeeping and things that are that would relate to more skill as opposed to somebody that's making widgets for your company or on the assembly line or even salespeople. That typically is not a contractor unless they're outside salespeople. The duration of the working relationship is also important. The longer the relationship, the more the government will see that as a W-2 employee rather than a contractor. So you have to be careful about having long-term contractors. The type of work that they're doing also is important. Is it an integral part of the company's business? So are they basically doing what the company does, like selling products or creating something or manufacturing something? Or are they doing something that is not part of the business, but it's more back office, R&D, again, accounting, tax, legal, things like that, that are not part of that company's business. And then we have the seventh additional factors, which is described as any factors that in some way indicate whether the worker is in business for themselves, as opposed to being economically dependent on the employer or company for work. So it's a lot of legalese, and it's going to be interesting to see how this plays out. It is a final regulation, but it's not a law, and government agencies do not have the final say on what qualifies as an independent contractor. So as I'm sure you remember from the pandemic, there were the CDC was issuing a lot of guidance and regulations that some companies and some states didn't want to follow, and those were not laws. This also isn't a law. So while courts usually give deference to most agency positions and regulations, they don't have to. And in this economy, in this political environment that is very pro-business, I think that a lot of courts may still find in favor of employers or companies, I should say, and try to tend to find 1099s where they can and not get the companies in trouble. So we will see what happens. As far as it would be remiss for me not to mention the other type of misclassification, which again, you guys get involved with. And this is whether somebody's an exempt employee or non-exempt from overtime. That's also under the Fair Labor Standards Act. And there are a lot of rules, mainly requiring three things. The person has to meet one of the professional exemption tests. I'm sorry, one of the, it's called white collar exemption tests. So either they have to be in an executive position, they have to be in an administrative position, or they're a professional, and those have all kinds of factors to them. Secondly, they have to exercise independent discretion and judgment on significant matters, which is a mouthful. But it can't just be somebody that's doing rote work. They have to actually have some important decisions that they make. And the third and very important one is they have to be paid on a salary basis. And right now, and I'm sure you're all aware of this, the salary requirement, the minimum salary for somebody to be exempt is $35,568 a year, which is a little over $1,000 a week. You probably remember a few years ago, it was 23,000. They were trying to get it up to, I think, 52 or 56, and they compromised at 35. It's now back pending to go back up to 55,000. And then there's a highly compensated exemption that's going to propose to go from 107,000 and change to 143. So watch for that. Those will be important for accountants. Any questions yet?
I have a question for you.
Yeah,
Yes.
So let's use the accountant as an example here. Um, I'm semi-retired. I've got a CPA. I want to do some work. I like Lorna's firm. I want to work with her clients, but I come and go as I please. But she says, okay, these are the ones you're going to follow. And I'm doing that for a year or two. Am I a 1099 employee or am I a W-2? I can leave whenever I want. I can tell her I don't want to do anything with certain clients or all the clients at any time, but I'm only doing things for her and her clients.
I would say that you're more of a part-time, very part-time employee. I don't think that's a contractor because you're, not that you're economically dependent on her for your work income. You're not doing this for other clients and you're not independent or, you're basically exclusive to Lorna's firm. So, practically speaking, there's a lot of times that an individual prefers to be a contractor and they just do it that way and nobody ever gets caught. It's rare to get caught, but it happens. So, I wouldn't encourage people, to violate it, but you have to be practical about it. So probably in that situation, nobody would say anything. But it's a
Lori,
good question.
how does it work with like shared employees or shared contractors? Like Insperity, where they provide, where theoretically they're an employee of one, but they're also working, they're doing work just for you.
Right. Well, I mean, and that happens with staffing agencies also. They're
Yeah.
typically they're the employee of the agency or for Insperity,
Yeah.
and they're assigned to work just as an accountant could be assigned to work for one of your clients,
Yeah.
for a year. But there's something called the joint employer principle, and that there was that's recently been in the news also because they're finding that there's so much that the actual company that they're assigned to is so involved with the work and the schedule and deciding, whether they get raises and evaluations, that they're considered joint employers, which is dangerous because the company that thinks this isn't my employee suddenly, has to make sure that that the agency is paying all the payroll taxes, making sure they're, that they're paying expenses. And, you have to give them training for sexual harassment. You have to include them. They're covered by all the employment laws. And suddenly an employer that might think we only have 10 employees and then we have these 50, shared, uh, uh, assigned people, suddenly you have 60 employees and now you're covered by these laws that require, that cover bigger companies. So it's dangerous. Okay. Let's get to the next big topic, or one of the big topics. Wait, did I skip? No, there we go. Is non-competes. I'm sure that you've probably read about it. It's been a focus of the federal government. A lot of people are moving around now, and I regularly hear from people, whether it's an individual or a business, non-competes aren't really enforceable, right? I mean, nobody really can enforce them. So I don't really have to worry that I have this contract, or I don't have to worry that I'm hiring somebody with a non-compete because no one's, they're not enforceable. That's not true. They can certainly be enforceable. It depends on whether they comply with the law, whatever law applies. Um, I'm sure that you've heard that the Federal Trade Commission is anti-non-compete and they would like to ban non-competes federally. We are expecting their ruling in April. So we will find out whether they've come out with, again, another agency rule that says there won't be non-competes in this country. And under their rule, non-competes, not only going forward, but any existing ones, any pending ones, even that were signed 2 years ago, but are still in force, they would all go away. They would all be void. Companies would have to tell all of those individuals, those aren't enforceable anymore. So we will see what happens. It's not going to affect NDAs, non-disclosure agreements, confidentiality agreements. It won't affect non-solicits, which I'll talk about in a minute. But it will affect whether somebody can compete, work for other employers. We know that if they do issue this ban, then it will become effective 60 days after they publish it in the Federal Register. Then employers have a 180-day compliance period. So it's going to be a while before it's in play, if it happens at all. And meanwhile, a growing number of states are banning non-competes. New York City is considering banning non-competes for New York City employees, and other states impose strict conditions. So non-competes and non-solicits are basically governed by state law for now. And it depends on the state. Some of them require certain minimum earnings. They don't want low-paid employees to be subject to these kind of restrictions. Other companies require that people be getting severance pay during their restrictive periods, so that at least they're being paid to stay home. A non-compete versus a non-solicit, there are differences. So a non-compete generally prevents somebody from working for or being a competitor, usually for 1 or 2 years. A non-solicit prohibits somebody from soliciting away clients, employees, sometimes vendors, sometimes prospective clients. And so sometimes you'll have just a non-solicit, which means you can work anywhere, but you can't take our clients. Other times you'll have what we call a de facto non-solicit, which is you can't solicit the clients, nor can you accept their business. So even if you don't come to them, they reach out to you, you still can't work with them. That's pretty much a non-compete. As I said, other restrictions like NDAs and intellectual property protections are not really in the same category. But states like Illinois does have some requirements. We have a 2022 law that was based on court cases, so it kind of codified what the courts were already doing. And so the requirements for non-competes and non-solicits post-employment in Illinois are first that the individual has to receive what we call legal consideration, which means something of value, for signing that agreement. Usually it's something like a signing bonus, or they're offered the opportunity to get severance pay if they're fired without cause, or stock options. But it has to be something beyond, here's a new job, you're an at-will employee, which means either one of us can end this at any time without any reason or notice. That's not enough to just give it somebody a new job, or even someone that's working for you. You can't just hand them an agreement and say, sign this. So you have to give them something. If you don't, then unless the employee stays at the company for 2 years after signing the agreement, the company will not be able to enforce the non-compete or the non-solicit. And it's a risk to hire somebody without giving them something, because they may leave sooner than 2 years. Illinois also requires, for non-competes, the person has to have annual expected earnings of at least $75,000, which is all W-2 earnings. It can include bonus, commissions, things like that. And for non-solicits, it has to be $45,000. And those amounts are going up every 5 years. So let's see, they're going to reach 90,000 by 2032 for the non-compete, and it's going to go up to 52.5 for non-solicits. You also have to give a person 14 days to review the agreement before they sign it. So if it's a new hire, you want to give this to them before they start work. Otherwise, they come in, they start looking at all of your information, they see who your clients are, they don't sign it, and then they go compete or take your clients. Also, the Illinois law requires that if the company unsuccessfully sues to enforce the non-compete or the non-solicit, the company has to pay the attorney's fees that the employee or individual incurred. So that's a great deterrent to companies to, they're not going to run into court all the time to enforce. They really have to have a solid case, and it has to be worth it for them. It has to be somebody that's really hurting them or potentially hurting the company by what they're doing. Any questions on non-competes?
Yeah, Lori, if there's an FTC ban, do you think it will follow something like the Illinois
Well, ban
law
is
or
ban. I
just
think,
ban? Like,
yeah,
okay,
if
okay,
there's a ban, they won't allow non-competes anymore. So
okay.
companies will rely on NDAs and non-solicits and those kind of things and hope that that works. I I have a hard time believing that there will be an absolute ban. I see that maybe there shouldn't be as many people that have non-competes, but there are certainly good reasons for companies to protect their goodwill and their business, and
Hmm.
I can't imagine that they're just going to go away.
Yeah.
So Lori,
Yes.
now I'm a banker, commercial banker, and I have a non-solicit, and I decide to leave. Can my new bank and I join a new bank, can my new bank send out an announcement that I've joined them? Can they do anything like that? That way, people who may have been banking with me would know that I had left, and I
They
would
can
not have been doing any kind of solicitation.
usually, and that's a good question. Often in these contracts, it says general announcements or general publications like that, that you're somewhere else would not be considered solicitation. It's not direct and nobody's doing it, knowingly doing that to the clients. Um, I will tell you that, not only can the employee be sued, but the old company will often sue the new company to try and stop them from employing that person or stop them from soliciting. It's considered an intentional interference with the individual's contract with their old employer. So I get involved in those a lot. Sometimes the new company will pay the old company to buy the employee, to buy them out of their non-compete. And a lot of times, especially in accounting, and I've just handled this for two different clients now, there are non-solicitation clauses that have a however. If you do end up working with some of these clients, you can pay us, basically a year's worth of the fees that they paid us. And it's called liquidated damages. So we won't sue you. We won't stop you from working for them, but you have to pay us to take them. And sometimes there's contracts that allow you to take clients as long as you pay for the clients. So
Is that sort of like a compensation for institutional knowledge?
no, I mean, that's just recognizing sometimes that clients, may want to go with those accountants or their advisors, but the business is losing something by that, and so they this is their way of saying you can do it, but you're going to pay us a year's worth of what they had paid us, and that's pretty common. So we then get to the National Labor Relations Act and unions. We've seen the rise of unions over the last several years across the country. I think a lot of workers realized during the pandemic that they have rights and they want more rights. Employers, that have been known as employee friendly and we'd never dream would be the focus of unions, like Starbucks, are suddenly unionizing. We have a lot of these arts organizations are starting to organize, and graduate students, and we know that college athletes are now employees, so they'll probably form unions as well. The federal
The athletes at Dartmouth did.
they formed a union.
Yeah.
Smart. So the federal law, the National Labor Relations Act, that supports the rights of non-supervisory employees. So it does not cover managers, but non-supervisory employees have the rights to organize and to talk about the terms and conditions of their employment with each other, including their salaries and their bonuses. And even when companies say don't talk about it, they are allowed to. And the National Labor Relations Board, which enforces this act, they've gotten very much involved in what employers are doing over the past several years. They're coming down on employers for firing or disciplining employees for their social media posts, especially on personal equipment on non-work time. And employers can stop some of that, but they have to be very careful. We had recently a couple of court decisions and the NLRB General Counsel deciding that severance agreements with overly restrictive confidentiality and non-disparagement clauses are illegal. And they've decided that's not just severance agreements, but employment agreements and other things relating to employees. Something that's, basically says you can never disparage us. You can never make any comments about the employer, the employees. That's way too overbroad. It has to be narrow. It has to be so that an employer can discipline somebody for statements that are maliciously untrue, that somebody's making either knowing they're untrue or not, with reckless disregard for whether it's true or not. And confidentiality clauses, meaning I'm signing this settlement agreement and I'm not going to tell anybody about it. Really, they can't be overbroad. They have to be, they can protect proprietary information, trade secrets. They've now said that if you have a severance agreement, you're a non-supervisory employee, they can require you to keep the payment amount confidential, but not really anything else. And the same thing has happened with workplace rules and policies. So now the NLRB is getting involved with employee handbooks and telling companies that it's illegal if you have policies that chill conduct that is protected by the law. So companies have to look through their handbooks and make sure that they don't go so far that, such as don't discuss your salary with your fellow employees. Things like that would be, unfair labor practices. And the rules, the policies have to be really narrow so that they're addressing special circumstances and they're not infringing on employee rights, unless they're covered by some of these things, such as maliciously untrue. Let's see. We also have some action in the last couple of years on affirmative action, on diversity, equity, and inclusion, discrimination and harassment. Nationally, it's been in flux and in many states. We've had a couple of key Supreme Court decisions in both last June. One was about religious accommodations. It was called Groff versus DeJoy Postmaster General. This was a male person who refused to work Sundays because of his religious beliefs, and the Postal Service had offered to find other employees to swap shifts with him, and that was the accommodation they gave him. But he couldn't find coworkers that wanted to swap, and so it didn't work, and he was still ending up working on Sundays or refusing to. So the post office fired him, and he sued under Title VII of the Civil Rights Act, which prohibits discrimination based on religion, a lot of different things, national origin, race. He claimed that they didn't accommodate him because the shift swaps weren't working. And it went all the way up to the Supreme Court, who found in favor of the employee and said that the postal office needed to accommodate him, and it made it harder for the employee to show that, it made it harder for an employer to show that this was causing an undue burden to the company, which is what the defense would be. We also had a few decisions on affirmative action. One was the University of North Carolina, and then the other was Harvard. They were sued, but claiming that their affirmative action programs violated the Constitution's Equal Protection Clause. And the Supreme Court ruled against the universities and said that they, can no longer use affirmative action and consider things like race or minority status to decide who they're going to select to get in. Some schools have found ways to still diversify now by focusing on socioeconomic status. My son-in-law works at University of Michigan in the admissions office, and he told me that they're finding legal ways to do that, because it's important to have a diverse class. It's important to give equal opportunities. At least some people feel that way. But there's the impact on private businesses now. There's been multiple lawsuits filed citing these affirmative action decisions to challenge diversity programs that private businesses use. We've seen litigation by white males claiming reverse discrimination, which it isn't reverse, it's discrimination. It's based on race. We have companies now needing to rethink how they do diversity programs. And meanwhile, we have some states like Florida penalizing companies and schools if they discuss or teach DEI or discrimination and harassment. So the states are in flux, and that will continue. We also had, about a week or two ago, guidance that came out from the Equal Employment Opportunity Commission on discrimination and harassment in the context of what's going on in the Middle East. And they basically reiterated protections, the ban on discrimination and harassment based on religion, based on national origin, people that are or are perceived to be Arab, Israeli, Middle Eastern, Muslim, Palestinian. So Title VII, that's the law that applied, and that's for companies that have 15 or more employees. However, the Illinois Human Rights Act covers employers with 1 or more employee in Illinois, and Chicago and Cook County have similar laws for all size employers. And this has been an issue. I've had several employers with employees, asking for them to make an announcement or issue a statement on their website, taking a position. And I'm sure a lot of you have heard of that too. So it's a difficult situation. We also saw some new federal protections for pregnant workers and nursing mothers. We have the PUMP Act and the Pregnancy Fairness Act, which again apply to companies with 15 or more employees. Illinois, though, is so progressive that we've already had similar laws for all size employers for the last several years. So the Pregnant Workers Fairness Act requires companies to make reasonable accommodations for limitations related to pregnancy, childbirth, or related conditions, just as they make accommodations for disability. And examples would be letting somebody sit down more often, receive closer parking, have flexible hours, more break time to use the bathroom. And then the PUMP Act requires employers to provide a reasonable break time and private space for nursing parents to pump milk for up to 1 year after the baby is born. Any questions? Oh, I see a lot in the chat. Tell me what we have, Lauren.
It was kind of a specific question. I think it might be sort of client related, so we can probably skip that. But I know that Sandy does have a very specific question, and I don't know if now is the time to ask her. We should ask at the end, but we
Oh, for
have,
overtime, you said?
yeah.
Yeah.
Do you want to? Okay. So we have a client who pays their employees for lunchtime, which is causing them to then, if they put in any additional time, then they're in overtime. So the question is, if there are stipulations placed on these employees, so I believe the stipulation is that they have to stay at the office and eat their lunch, but they get paid. If they
If they're
then,
working through
yeah,
lunch.
but they're not,
those
but
are-
they're not technically working, but they're eating their lunch. That's where this is where that question goes. So my interpretation was, if the stipulation is that you have to stay there, you're working. So that was my,
Yeah,
lawyer.
that's basically right. I mean,
Okay.
well, so non-exempt employees are supposed to get breaks, and that's regulated by law. And if they,
hmm
and those, they don't, the meal breaks don't have to be paid. So you
Right.
can, but if an employer is generous enough to pay somebody for a meal break and not make them stay at the company, then those aren't considered work hours. So that shouldn't cause overtime. But if somebody is required to stay at the office, then that's not really a break. That's like on call kind of.
Yeah.
Then that's considered work hours. So yeah, they would be getting into overtime.
Yeah. Was that an accurate interpretation, Sandy?
Yeah, I think that's accurate. So, if the employer decided to, change the rule and say, okay, you don't have to stay in the building, because from my understanding, everyone's getting an hour-long break, lunch, and getting paid for it.
But has to
So
stay.
but they have to stay. If they stay in the building, he'll pay them for it. So apparently everyone stays because everyone gets paid for lunch every single day. If
Is the
he were to
office open in that hour? Do they actually see patients in that hour?
I don't know the answer to that, Lori. Would that make a difference I guess that would make a difference, wouldn't it, if the office was shut down?
If it's a complete break, if they're not required to do any work. But I mean, the question is, are they on call? Are they there because if somebody comes in, they're going to need to do work? Do they do work from time to time during that hour? Or is it just, go to the lunchroom and we'll pay you? Because if they don't have to work at all, then it's a break.
There's also consideration, I think, that they provide the lunch because they know that people won't take the full hour. They'll be more productive. They think they're getting something for it, and they're going to actually be working. After 35 minutes of lunch, they're back at work, as opposed to a full hour where they have to worry about them coming and going. I know law firms used to provide meals for lawyers, and because they knew that they would stay there and eat it, and they wouldn't take the full amount of time that they could.
Yeah, but you're talking about exempt employees versus
No,
hourly.
No, I
Right,
understand that,
yeah.
but it's the same psychology.
Right,
Yeah.
right. Well, then you have them, they should be clocking in and out for, if they're gonna eat for 35 minutes and go back to work, then, that's
Yeah.
what time clocks and.
So
or time
I
records
think
are.
I think we'll have to take this to a offline discussion because we'll have
Okay.
to talk to the client, kind of explain it, and then they may have to come up with a new policy, would be my guess.
Right.
But yeah. Okay.
Yeah, happy to talk, follow up.
Okay.
Okay. Speaking of pay, so we talk about pay transparency is the number one change we think coming to employers. We have a lot of states that have salary history bans, and some have pay transparency mandates, and some states like Illinois have both. So in terms of typically employers probably may have a salary range for a position or a set salary, and sometimes a candidate is rejected because they're considered overqualified, or that because they were at such a high level of pay based on their career or based on their last job that a company feels that it's not going to be the right fit. Or on the other side, an employer may lowball somebody on their salary, or even an existing employee based on the person's salary, the last salary they had or the salary they've been used to throughout their career. And unfortunately, that practice has the consequence of perpetuating discrimination, usually against women and minorities, and then keeping people down. So the two kinds of laws, salary history bans and transparency, are aiming to eliminate these situations and put people at a level playing field. Salary history bans have been around for a while. Illinois had one since 2019, and it basically prohibits employers and recruiters from asking candidates what their salary is, or what their salary history is. And candidates can voluntarily disclose that information, and an employer can ask what salary or range somebody is looking for. But if a candidate voluntarily discloses what their history was, the employer can't use it to decide on their salary. So I think it's hard to unring a bell, but at least we know what the law is. And pay transparency laws go even farther. Illinois will have one effective next year, and that is going to require employers to post in their job postings the pay scale and the benefits. Or if there isn't a posting, then when an applicant requests it or before they discuss compensation, they have to be, truthful about what the pay scale is and what the benefits are for that position, because it's hard to go into interviews and not know what a position commands, and it's hard to ask other people, it's too secretive. And even being an existing employee and not knowing what what those positions command at your company, that puts you at a disadvantage. So that's going to be the law next year. We also have a lot of we have federal, the Equal Pay Act, and many state equal pay laws, which are generally focused on equal pay based on gender. The Illinois Equal Pay Act also prohibits discrimination against African American employees in pay. And now employers that have at least 100 employees in Illinois have to file an equal pay registration certificate with the Illinois Department of Labor to confirm that they are providing equal pay. Oh, and speaking of gender and discrimination, just remember that for any of your Chicago first of all, Illinois employers all have to give 1 hour of sexual harassment training to employees yearly. If you have anybody that's in Chicago, it's an hour of sexual harassment training for non-supervisory employees, 2 hours for supervisors, and then everybody gets yet another hour of bystander intervention training. So make sure your clients are following that. Okay. We've
Is
had
that every year on that training?
that's every year.
Thank you.
Yep. And if anyone's interested, I provide that training, so I'd be happy to talk to you about it.
So I have a situation that came up today. I'm in a networking group. These are just people who have gotten together. It's sort of semi-formal, but every now and then there's an inappropriate comment that comes out. Is that tolerated? Is that something that's just needs a discussion? How do you handle something like that
In the networking group?
in a networking group?
So, I mean, it's not illegal because you're not, there's employment laws wouldn't cover you, and it's not a public institution, so they're not public accommodations, but it's still not comfortable for people. And I think there has to be a way to handle that. The problem is you don't always know your audience. And so even if you can't see anybody being uncomfortable, you don't know that they feel uncomfortable. People don't want to always say something. You kind of have to err on the side of the most sensitive person. And if it seems to you like that could be offensive to somebody, then I would say do something about it. Take the person aside. I mean, you don't have to, reprimand them in front of everybody, but a lot of times somebody doesn't mean, they don't mean to be offensive. They didn't realize that they were, that it was anything inappropriate. And once you tell them, they realize that, oops, I shouldn't have said that, and they apologize, and they learn, and it doesn't happen again. So that happens in employment too.
Lori, Sandy has a question about PTO for salaried employees.
Yes.
For salaried employees, because I know the rules are you have to give them their whole salary if they work even 1 day during the week. So any hours, they get their whole salary. If a salaried employee.
You can dock them for certain things. I have a whole list for that. But I mean, if they take a full day off for personal reasons or for medical reasons, and they're out of PTO or out of sick leave, then you don't have to pay them for that. But you have to pay them if they come for a half day. But anyway, go on. There are some.
So there's a list. Well, my understanding is that, like, so if they get hired, the first week of their hire and the last week of when they quit, then you can like adjust the pay
for those days, right?
For those days. But I have a situation where a salaried employee is taking PTO for taking 3 days off, the last 3 days of the pay period. So she worked Monday and Tuesday, And her supervisor told me, oh, I don't know if she wanted to use her PTO. And, my response was, I believe she has to use the PTO because we're not allowed to adjust her pay. So she has to use her PTO. So it sounded like she wanted to take the 3 days off and not use her PTO.
Right, because then save it for later, and then you'd still have to pay her, and that wouldn't be right for the company. Right,
Right. So if somebody had PTO and didn't want to use it, and that was fine with the company that they didn't use it, I don't know why that would be okay. But if the person said, well, I want to save my PTO, could you then adjust the pay for that week?
it
Even
depends
though,
on the reason for those absences. So, like I said, there's a list and depends on, if it's for sick reasons and if they're out of sick leave. And so if it's for one of the reasons, if it's not for one of the exceptions, then they would still have to pay them for that.
okay, so
So
they have to
couldn't
take their
really take it
PTO.
unpaid. So they might as well, tick off the PTO and not save it for later.
Okay.
Good question.
What,
So Lori, we don't want to like rush along here, but we're actually almost at 6:30.
Right, I know.
I know you have more slides, so we could have you come back another time if you'd like. I don't know if you want to try to wrap up a couple topics
Yeah,
or how
I
you
have,
want to handle that.
let's see, I have like 4 more slides, so I probably wouldn't, I can't really, well, I can go to this part, which is next steps for at least some of it.
Okay.
And yeah, I can always come back if you want, and we could just do questions too. But things to remember, at least I covered some of this. Make sure you look at worker classifications, 1099, as well as exempt versus non-exempt. Look at your employment contracts, severance agreements, employment handbooks. Make sure that they comply with the non-compete laws and the National Labor Relations Act. Make sure that managers are trained on discrimination and harassment and know what their obligations are. We didn't really get into temps. Secure choice, I know that was one that you were interested in. What I can tell you for that is that under Illinois Secure Choice Act, let me find that. Employers with 5 or more employees in Illinois have to provide a retirement plan. It could either be the Illinois Secure Choice Plan or, a retirement plan 401k that you get from a private plan. But
Can I
that-
ask a question about that real quick though? The Illinois Secure Choice Plan. I have a couple of restaurant clients. It would seem to me that due to the nature of types of employees they have, that would probably be the most beneficial for them. But I guess the question I have is if they work at 2 different restaurants, let's say, and they both offer them this Illinois Secure Choice, is it still underneath the employer or is it one account for the employee? I guess I don't. Do you know
that I
what I'm
don't
trying
know.
to say? Okay.
I don't really handle benefits. I know that this
Okay.
law applies and I know that companies have to do it, but
The
benefits.
details we don't know. Okay.
Yeah,
All right.
that I don't
Okay.
know.
Okay.
That's a good question. I mean, I wouldn't think, I think you'd be under just one plan. And I'm not sure that the employer is paying anything. I think you're
No,
just offering it. So
they're just kind of the sponsor,
like
but I
yeah,
just don't really understand how that thing works. So, okay.
right. I mean, you have to offer it. Obviously, the employees don't have to take it. So I guess if
Right.
they take it at one place, they shouldn't take it anywhere else.
Lori, what happens if there are 4 W-2 employees and 3 1099 employees?
Well, there's no such thing as a 1099 employee.
Okay, well, not being so technical, I have 4 W-2s and I have 3 people I pay through 1099. Am I required to have a retirement plan?
Not if those are true 1099s. If they're,
Okay.
if they're really not W-2s and there's no risk that they are, then
Okay.
you're okay.
Okay.
You're not an employee, right?
Me?
So,
Yeah.
so Lori, I think that we'll talk. We'll probably have you come back again. The I think the takeaway here is there's lots and lots and lots of stuff under this umbrella that we don't know, our clients don't know, and we need to direct them to you if we have any if they have any questions or we do.
Yes, feel free to. I'm always happy to do an introduction phone call, and a lot of times, I'll know the answer right away, and it'll be a 5-minute phone call and it's easy. And other times we have to do research or gets more complicated, but happy to help. And thank you for having me again. Thank you for all your attention and taking
Yep.
time away from your workday and dinner.
Thank you.
Yep.
Thank
Thank you,
you.
Lori.
Thank you so much.
Yeah, thank you.
See you soon.